You're welcome back to Newsfile. This is your most authoritative news analysis show. I wish to apologize again for the technical difficulties we encountered on radio. I guess that you didn't miss anything. If you did, this evening at 9:30, this show will be repeated on this platform. In fact, shortly after we are done with the show, it is available on YouTube and also on myjoyonline.com for you to download and to listen to the entire discussion. We had an interesting perspective brought on by Ernest Kofi Aboche, Dean of the Gimpa Law Faculty. Now, let me share with you your messages before we go to the Special Prosecutor's office that is being created. A bill has been put into Parliament, but it appears that that bill is not enjoying the smooth process that had been anticipated. Now, this one is from Dr. Evans Adu in the USA. He says, slowly but surely, is our decision parameters as a nation being shifted to the public space without respecting the law. We are becoming a country of feeble nuances, though democratically procured. The developmental agenda of the government is not receiving the needed scrutiny, and it has been a battle between few tangibles and more intangibles. If a petition on the EC boss has been sent to the president, let us patiently wait for the due processes to be exhausted instead of drawing parallelisms between perceived faceless petitioners, the presidency, and a political party. This heightened imagination is needless. Dr. Atu Adu. Okay, appears it's in time. It says it's sending from Edum Banso. All right, and then YK Ansa Yeboah says that please ask Kwekubako for us if he wanted to just discuss just Iyoko. Why is he telling us it is the same as the one sent to His Excellency the President? Tell the latecomer I like him. He speaks refined English. Not this. No, okay, thank you very much. Well, but Kuku is, you may know, the game is to avoid being roped into any contempt. And Tamale Ibrahim Kopa says that the responses of the chairperson of the EC were too emotional and don't reflect the status of the office. Among other things, Madam Charlotte Osei claimed that the petition is politically motivated. This statement is far below standard, given the office she occupies. She ought not have made that statement. Bonti Benjamin in Achim Ebuakwa says that government should probe the issue against the EC boss and apply the law if it turns out to be true without any favor. Ghana deserves better, if not the best. Oliver Bamba in Salaga says the spurious allegation by the minority leader to cite government involvement in the entire EC row was very unfortunate by all stretch of imagination. The earlier we depoliticize this matter, the better for our infant democracy. Nana Akwesi Safueje and Kwadaso, you used to send from Diamond Street, right, or Gold Street. You stopped living there. He says, this brouhaha is needless. Let's get an audit report before these constitutional procedures or processes are triggered. Let's be circumspect in all this because our constitutional democracy is being tested. Musa Abato in Kumasi says, this is not the first time we have had such baseless allegations against EC boss. The unjustifiable attacks against the EC boss by the NPP kingpins before, during, and after the election is evident enough to prove they are behind this frivolous petition. Gorazo in Kent, UK says that it's painfully sad to witness the rather juvenile manner in which the minority, who are meant to be the obvious alternative government, are behaving. You don't say anything beyond that. Okay, thank you for your messages. Frank Anderson sends this from the UK, of course, wants me to read it, that that dude, Kweku Bako, ought to have read law in addition to journalism. The guy's brain is a mind failed. Okay.
His book short.
Okay, right. We'll move on to other issues. I gather that you still have a lot of messages on the impeachment scare on the EC, but we'll deal with some of them as and when you bring in those messages. Okay, let me take this one from Danny Kojo Ampofo. He's sending this from Dallas, Texas. He says that, Samson, blessed morning to all your panelists. Please, what kind of pedestrian politics and political galamsey is the NDC and its leaders engaging in linking the NPP to Madam Charlotte Osei's saga? Okay, like Hassan Ayarega has rightly asked, I will ask, what is the interest of the NDC in attempting to shield Mrs. Osei and playing political gala with the issues of conflict of interest leveled against her? Ghanaians deserve a clean electoral commission and a commissioner we can all vouch for. Thank you. Okay, thank you too for sending in those messages. Now, let's get to a bill that is in Parliament, and it's a bill that we have all been waiting for because it was one of the key promises of the New Patriotic Party and Nana Akufo-Addo. And now they're seeking to roll it out. It appears, and people are concerned, that we appear to have put a hold on criminal prosecutions of the so-called corrupt persons that we spoke about whilst in the political campaigning, waiting for this bill to happen as a law before we did that. Many are not happy about that because the Attorney General can be doing the job whilst you put that office together. All right. So start with you again, Obi Amwa. For those who have not followed what the Special Prosecutor's Office is all about, why is it that important to the New Patriotic Party and the government?
Well, thank you again, Samson. As you rightly said, we stated that in our manifesto that we needed a special prosecutor, indeed an independent special prosecutor, if we wanted to fight corruption to a certain level. Indeed, we were informed and guided by what had gone on through our at least fourth Republican dispensation. Typical one being the Martin Amidu issue, that indeed it got to a point where the impression was created that when he wanted to fight corruption, he was fired, and that he was not allowed to do his work as Attorney General. Beyond that, it's obvious that if you run in a government and then you want the Attorney General who is appointed by the President to be that independent, there are a few roadblocks. One, if you have a president who doesn't want the Attorney General to investigate his own cabinet, you could reshuffle the Attorney General any day. That is a fact.
Right.
So what we have tried to do is to bring forth a certain office based on the Act, which would insulate such a prosecutor from interference or undue pressure from the executive, in the sense that once the person is appointed under the Act passed by Parliament, there's a certain security of tenure. 7 years that he's supposed to run, then he's at the level of the Court of Appeal judge, and that if you want to remove him, you have to go through the same process like what we've discussed about the EC chair. And we thought if such independence was established, such security was granted, then you could have a person who would be independent enough to start investigations and then end with prosecution. That is all that we're trying to do, just to also show that indeed we could have a certain office where the president, after the appointment, could have minimal interference and influence on such an office, so that we could also assist in fighting corruption. And if you read the memo has spelled out exactly what we expect the
argument, though, is that what you're
prosecutor to
seeking to do will not pass constitutional muster.
No, I don't know whether you've read the bill. I don't know whether you've gone through the bill, but we've tried as much as possible to make sure that it's covered under Article 88. And if I may be allowed to read Article 88
Please
again,
go ahead.
which we all know. The 88.4 especially says all offences prosecuted in the name of the Republic of Ghana shall be at the suit of the Attorney General or any other person authorized by him in accordance with any law. So here, under the bill, the person will be authorized by the Attorney General.
In accordance with this law.
In accordance with this law.
Okay.
And once that is covered, we think that it will not infringe on the provisions of 88.4. And in any case, the beauty of it is that once it's in Parliament, we can, at the consideration stage, we can delete, amend, whatever, to make sure that it complies with the Constitution. But on the face of it, this is what it is, and I don't think there's anything wrong with it.
But what's the urgency that you are seeking to pass it through a certificate of urgency? Well, and for some of us, we are not particularly pleased about some of these bills going to Parliament under certificate of urgency when this is to fight corruption.
Yes.
The power of the people to assist in fighting corruption. You are not interested in doing that through a certificate of urgency. What am I talking about? Right to information.
Well, you have a point, and that is the point that the committee has made. But that wasn't the issue on the floor. The issue on the floor raised by my good friend here was the fact that he was former Deputy Attorney General, and by the fact that the bill had not been gazetted for 14 days, it could not be laid in Parliament. That was his point. And indeed, if you look at the bill, date of gazette notification is 14 July 2017. But then the majority leader made a point that if you go to 106.13, it gives exceptions there. And as far as it's concerned, if this bill is referred to a committee determines that it's urgent, then you could just waive this 14 days thing. You
failed to secure the endorsement of the committee that this is urgent.
Well,
that's terrible. I mean, the supporters of the NPP, those of you who are particularly on that committee are taking such a flack on social media. They say, "What is this? You can't get this through in Parliament."
No,
you have all the majority.
No, one, the committee is made up of majority and minorities. Two, the committee is to advise, even if it's their government. They have to advise the government well. The major issue wasn't whether we could waive the 14-day gazetting. That one, the Speaker ruled on it. The Speaker referred it to the committee. The following day, the NDC came back to say that they don't have copies of the bill, so it should be withdrawn. The Speaker ruled on it.
The entire Parliament did not have, not only NDC members.
I've had
this. I'll get you shortly.
Yes. Then the Speaker ruled that we should comply. The table office should ensure that members have copies. And that's what happens in Parliament. Sometimes they lay an instrument which is supposed to run for 21 sitting days. Even after 15 sitting days, we haven't seen the instrument. We had to complain, and the Speaker will say that make sure they have copies. I'm not saying that's the right thing, but I'm saying that just the following day, they came back saying that we don't have copies. If that's the case, withdraw the bill. And we were wondering. The Speaker said, table office, it's your job. Make sure everybody has a copy. So
when similar things were happening,
we were complaining.
The NDC was in government, you were complaining.
We're complaining. I'm saying that we didn't say that we supported
it. So why are you disturbed that they are complaining about?
No, we are surprised that they said we should withdraw the bill. That was where the surprise was.
Why take it there in the first place when you have not, ensured that there is sufficient copy as the Constitution provides for?
It's not for us to ensure that there is sufficient copy. What if you read the Constitution very well and understanding all this?
It's a table office.
It's a table office. So, if, for instance, in this case, Attorney General will make copies to the table office. The table office should ensure that we all have copies through the assembly press. That is why the speakers always give directions that table office make sure that people have copies. Sometimes even when reports are are laid in Parliament. That's what happens.
Okay.
And then, just to end, but which I've said already, the committee came back and said that we think that we should have more time to look at this. Parliament is rising by 2nd August. We don't think that we should use the rest of the period to conclude this. We need to still consult stakeholders, etc. So it shouldn't be under certificate of agency. We should rather let it go through the normal route.
Okay.
That's the end of the matter.
Right. Dr. You have been noted as one of those who has, advocated against this, and we are told that you orchestrated what happened yesterday so that it didn't go through the process to be dealt with as an under certificate of emergency agency. What exactly happened yesterday?
Something it's interesting that you are using the word orchestrated. It's as if I deliberately attempted to stymie the process, because
that's what it
as
like.
the perception is out there that we are against the enactment of this bill. I mean, by we I mean the minority. But that is not the case. We have said that we are in one mind with the majority as far as this bill is concerned. We also committed in our manifesto to fighting corruption, but we wanted to do things differently. If you look at our manifesto, we said that we're going to resource and make autonomous the office of the Director of Public Prosecution, as has been done in Kenya, in order to be able to fight corruption. So, for instance, we wanted to give the Director of Public Prosecutions the autonomy in terms of resources, in terms of personnel, getting her own investigators. The current DPP is, the current
Saying
DPP
her
is,
because the current
DPP
is a lady.
Is a lady.
Well, we have had a lady before this lady, so
yes.
for a while.
Yeah. So we wanted to get her, her own personnel, investigators, forensic analysts, auditors, and so on and so forth. That was what we committed to doing, because it was our view that in light of Article 88 of the Constitution, it is very difficult to hive off the office of the Attorney General and then give prosecutorial jurisdiction to someone who will be independent and not accountable to the Attorney General. This is the view that we took after deliberation. The former Attorney General, Marete Brew Apiopong, took that view and advised our party that it is better for us to do it this way. And this is what we said we're going to do. Now, they have decided that they promised they were going to create an independent office of special prosecutor who will deal solely with corruption matters. Now, something my brother Obiamo, and by the way, were classmates in law school. He has proffered an opinion that says that the bill is supported by Article 88(4) of the Constitution. But what 88(4) seeks to do is a situation other than the creation of an independent office that is not accountable to the Attorney General. So, for instance, as a matter of practice in the office, anytime we had requests for prosecutorial authorization from agencies such as National Lotteries Authority, because they wanted to prosecute lottery offenses, EPA for environmental offenses, and so on and so forth, we simply issued a fiat, or we would, in the form of an EI, an executive instrument, authorize them to conduct prosecutions. But that means that on a regular basis, they are accountable to the Attorney General, because all prosecutorial authority is vested in the Attorney General.
Right.
So when 88(4) says, may authorize under any law, it is referring to statutes that create offenses that are of a special nature, that the Attorney General can authorize people, who are working in those entities to undertake prosecution but report to her.
Okay.
Now, if you look at police prosecution, for instance, there's a law in existence, the Law Officers Decree, which says that the police officers of a certain rank may be authorized by the Attorney General to conduct prosecution. But again, something that all the police dockets come to us for us to be able to okay them before, and they cannot prosecute certain kinds of offenses.
Right.
You see, so there are a lot of difficulties. I have reviewed the bill thoroughly, and there are a lot of difficulties with the bill. But as he said, when it comes to the consideration stage, Parliament is at liberty to virtually rewrite the bill and then send it to the president. And if the president thinks that the rewritten bill is not the one that he wants, he will refuse to, give his assent for purposes of the bill coming into force. But I want to put it on record. I've said this several times, and I want to say it again. The NDC, as a party, is not against the creation of the office of the Special Prosecutor. We want this country to be better off if corruption is, minimized or eliminated altogether. So we will be the last, people or the last party to say that the office should not be prosecuted, established. But we would want the office created in accordance with law. We want compliance with due process of law. And that is why I raised the issue of compliance with Article 106 of the Constitution. Because I had made my checks at the AGs and at the Assembly's press. And the information I got reliably was that the bill had not yet been gazetted. In spite of the date that is put there, factually, the bill, this is usually the date put in by the AG's department. But when we put that date, the Legislative Drafting Division ensures that the Gazette notification has to be on that date.
Okay.
So sometimes we have to send staff from the Legislative Drafting Division to sit at Assembly Press to ensure that the notice comes out. And this date was not the date of Gazette notification. If you want, you can go to the... Yes, I am telling you that on authority.
If you don't mind,
yes.
The permission of...
Yes, go ahead. Go ahead.
What is this one?
Okay, so that's the certificate
is that
of gazetting.
Is that on the 14th?
Take it. Yeah, take it.
Okay, so this is February 14. Friday, 14 July 2017.
And
Right.
the top there, what is it?
And it's about a number of things here. I'm sure when you go in the Gazette notice, you will see
Look at it.
that it
sources are
would
not helping
have... Okay, so Office of the Special Prosecutor Bill 2017.
Okay.
It also included the Coastal Development Authority Bill 2017, Middle Belt Development Authority Bill, Northern Development Authority Bill, Zongo Development Authority Bill. So it said the following bills are published today. So duly gazetted.
When was the objection raised? I need to check that.
19th. The Hansard is here. You guys, this is July 19th.
Okay.
That's when you were talking. Muntaka and Haruna Idris both said there was no gazetting.
Yes,
but
but,
that's
but
14th.
you see, you have to also be careful, because if that morning I called assembly press,
No, but
it's
you-
possible.
The person
It's,
didn't
no,
give
it's
you the
possible.
right
It's possible
information.
that this was printed in the evening.
Oh, come on.
Of that day. No, I'm telling you,
but
it's
it's not
possible
the
that
day.
this. No, but the thing is that
We
at the
can't do
time
that
that
to the institution.
at the time that the bill came
This
to us,
is-
Yes.
at the time that the
19th.
bill came when it was laid somewhere around noon. Okay, the checks at Assembly Press was that
Official
the Gazette,
checks.
the
You were-
official
Official checks or official
no,
checks?
I checked and I was told that the Gazette notice
but
had not
Dominic,
yet,
Yeah, but
been
we,
Dominic.
as a journalist, I
Okay.
had it.
Dominic,
So-
with all due respect, all of us, we've been communicating with
Kobe,
Assembly
when
Press.
did you buy this one?
This, my boy went for it 14th.
No.
Oh, no,
It cannot.
It's my
Dominic,
business.
14th at
You know
what
what?
time?
It's my business.
14th at
which
what
I've
time?
been doing for years. I have all these gazettes and things in Hansard. I keep
Sometimes
them
they subscribe.
religiously.
When you subscribe, they
yes.
even bring it to you.
So I don't know why you
so
want
why
to
did it
interrogate me.
appear also that even the
Yes.
majority leader
Yes.
was unaware that
See,
this
now,
had been
that's
gazetted?
where I'm coming in.
Yes.
See, let's be honest. I think the majority itself was part of the problem. It appears a certain lack of coordination existed between the majority side and the office of the Attorney General.
But the deputy was there.
And yeah, but there was a deficit. There was a certain problem in terms of communication. Why the decision was even taken to run this thing under certificate of agency was in my, it didn't make sense. They didn't have to. It was needless. I'm telling you, somebody decided that let's do it under certificate of agency when this was available, and it's 14 days.
Yes.
So from 14 to 28th, it will happen before Parliament rises.
Just to balance this
no,
now.
I mean,
No,
just
just to
no,
balance
no,
this now.
no, let me make
a small part to send the
no.
certificate of agency.
Let me make
both
mine.
the NDC and it's a small point. Both the NDC and the MPP ridiculously have abused the certificate
Over
of
the
agency
years.
principle, and you've gotten to a point where, frankly, Parliament conducts the most urgent businesses under a certificate of urgency, which is sad. And that is the reason why a number of major parliamentary transactions, the fine detail, have hidden the most important things.
Yes.
Because members are not given the opportunity to digest it.
And
They are
that I agree
smuggled.
with you.
So the
For
certificate
the
of
past
urgency,
8
this
years,
time,
it's been
I think the speaker will do himself some good, and this parliament some good, and Ghana some good, by probably giving some directive. I don't know what the rules say in part, but maybe some speaker's direction, like equivalent to what the Chief Justice does. Some speaker's direction of the circumstances under which a certificate of urgency can be
standing
activated.
orders.
Because everything is smuggled under certificate of
And
urgency.
to be honest with you, it's
No,
not
it's been done over the
peculiar
years,
to
and it's
this
bad. I
Fourth
think it's really
Republic.
bad.
If you go back into our parliamentary history, it's been recurrent.
Yes,
But
but something. The point that I wanted to make is in respect of the Gazette notification. No.
I have shown you. This is
Yes,
official
in spite of
It's
your
okay,
evidence.
it's okay.
If you-
Let's move on. Let's move on then.
No, please. This is important. In spite of Kweku's evidence, right? The 14 days had not elapsed
Yes.
before the laying of the
That's
bill.
right.
So my
nobody-
objection was still, constitutionally
Yes,
valid.
but you went on to say that it
than
had not been gazetted.
Yes.
That
Okay.
is where the
So
problem
that's a
was.
material
Had a
fact that I
difficulty
can
of their own.
concede. If I mean, on the basis of what Kweku has presented this morning, my sources probably were not reliable, right? But the point still remains that 14 days had not elapsed before the laying.
Yes,
And,
so it was
the majority leader,
wrong with
majority leader sought to rely on Article 106.13.
106.13, yes.
And 106.13, was misrepresented.
Why?
Because
educators.
There was no
Yeah.
need for them.
Educators, the constitution is
Well,
here. Why?
Do you want a debate on 106.13?
Yes, go on.
Okay,
Go on.
good. Now, if you read 106.13 very well, it says that you can dispense of the need for Gazette notification if a committee of Parliament
Yes.
determines that the bill is of an urgent nature.
Yes.
Right? Now, the determination of the committee, in my considered view, must precede the introduction of the bill in Parliament.
No.
It cannot be the fact that the committee, the bill is laid, then you go back and give it to the committee, and then the committee comes. At what stage in the process is the committee coming to tell you that the bill is of an urgent nature and should pass under
It's when the bill
order
has been-
119?
What have we been doing under certificate of urgency? What have we been doing?
Well, the
Okay.
practice is wrong.
Yeah, I need
practice
us to
is
move
wrong.
away quickly from here and look at the substance. Yes, okay. So the basis for which this bill yesterday did not get
through.
your endorsement at the committee was what?
Now, the basis was that we had looked at the
It's not
the
a minority
memorandum.
basis. The committee.
It was a
I'm
committee.
talking about
Yes, it was a
the
committee.
chair
So,
who
and we were
presented it.
unanimous. We were unanimous. For once, we're unanimous on this one. The memorandum didn't make the argument for urgency. Okay, so on the face of the bill itself, there was no argument for urgency. Then also, we had made efforts to get the Honorable Attorney General herself to attend upon the committee and to make the case for urgency. She did not come, and neither did she send any of her deputies to come. So on the basis of that, and in view of the fact that this is an important bill, and we have a number of civil society organizations that are very, very interested and very much invested in this bill, we thought that we should allow a public consultation to take place, so that we can have the input
Some
of all
members
these
of the
persons.
public may not understand when you say that the minority is not against this bill, because we have already had indications that you may even be proceeding to court to shoot it down.
They've made statements
No,
against it.
in terms of
They said it's
compliance,
witch hunting.
in terms of compliance with the Constitution and laws of this country, that is what we are saying. We are not saying that we are against it to the extent that we will not allow it to pass. But something, if we allow the Constitution to be, breached just because a president has made a promise and needs to fulfill that promise, are we doing this country any good? So if there's a breach of the Constitution, it's within our right to go to court, and to say,
Your
to get the
opponents
court
say
to
that
say,
you are scared, really.
no, not at all. We are not scared at all.
Okay.
Because something, is this office being, set up to prosecute corruption or to prosecute the NDC? It's to prosecute corruption.
Okay.
And I'm sure on both sides of the political divide, there are corrupt politicians, and there are also politicians of integrity.
Right.
So let us see how it plays out.
Mr. Boche, are you assured that an independent prosecutor, special prosecutor, so to speak, will secure us a process other than what we are already familiar with, where we are trying to, the mischief we are trying to cure? Will it ever? Because the person will still be appointed by the president. Is that not as provided in this bill?
We may make some stride on the basis of how we proceed. And so before I start, let me just say, first of all, I think acknowledgement should be made where it is due. I think that the NPP government and the current Attorney General, for whatever it is worth, should be commended for having taken the bold step of doing something that many have spoken about for years, but nobody really does anything about. I think that historic effort and initiative ought to be recognized. So it's something I'm quite excited about. I think it's a good thing, and honestly, I'm happy. The former Attorney General, and on the other side of the aisle, says, frankly, corruption has no colors. We all chase after one thing. It's a bad vibe.
We used to have an Attorney General not separate from the Minister of Justice, and we threw it away. We went to a constitutional review commission. The populace proposed that they wanted the Attorney General decoupled.
I have never understood the people who make that assertion, and I've heard it from quite some respectable people who have a lot of admiration for. It simply doesn't make sense. When you separate the Attorney General's department from the Ministry of Justice, what you've done is to create two ministries.
Yeah.
Yes. And you've done nothing. Essentially, it's the same thing. In other words, the same functional flaw, the same structural flaw. They both report to the president. They may both sit in cabinet. Two different ministries, one performing a specific mandate, the other another mandate. You solve nothing. The problem has always been...
does it really require constitutional amendment, that separation?
Yeah. It does to a point. It doesn't require an amendment per se, because the Constitution speaks only of the Attorney General.
Thank you.
Yes. The Ministry of Justice is a ministerial creation,
that's right,
which is at the discretion of the President.
Thank you.
Under the Constitution that allows the President to create a million.
So you endorse the position of the Constitutional Review Commission. Okay, let's go on.
Well, I'm not sure again. You like boxing. I do not endorse. My point is, I do not endorse the proponents of the separation of the Ministry of Justice from Attorney General's Department. What you do is to create two inconsequential things.
That's the view of the
commission. We have the same problem. Okay. But let me just make the point that the functional independence of the proposed ministry, of the proposed office is what is of importance, or what should be of importance to all of us. Yes. The reality is this. The current system has a certain structural flaw, and that structural flaw is that there exists a ministerial and professional community between the Attorney General and other ministers. You can't deny that. They are, as they will say, primus inter pares. They are, equals among. They function in a certain equal way. They are ministers. They sit in cabinets. They pat each other. But they meet in close proximities. That makes prosecution of one by the other uncomfortable in practical life. You can speak all the theory, but in practice, it is uncomfortable. That they have to meet, they talk to themselves, they prosecute the same political agenda. They sit in cabinet, take key decisions. And as they sit in cabinet, one knows that the other is under siege by them. It's an uncomfortable business. And so the reality is many countries have understood this. The model globally is moving away from this political Attorney General who responds to the president, prosecuting other people, by setting up an office whose business is just prosecution. So the current system is flawed, and that is why the attempt at the functional independence of the proposed office is something that ought to be lauded and supported by all. I just think, however, I saw something inside the bill that a bit troubles me, and that has to do with the character of what can be prosecuted. If that is not addressed, I don't think the bill will amount to much. And the bill speaks primarily about the fact that before a prosecution can be done, we have to make an assessment of, one, whether the corruption involves a charge or involves an impact on the substantial national assets. I think that every theft, and I'm using the word theft, I think every theft of the national resource by a public officer has to be prosecuted. It speaks of the fact that it constitutes a substantial proportion. That's huge. Basics. It means we are not even just dealing with the question of theft per se, but we're dealing with a relativity to the GDP, national proportion. A substantial proportion of the national resource or assets. That's huge. And what it means essentially is that probably unless we are talking of the multiple millions of billions, we probably cannot prosecute this. And while I can understand that there's a certain reason, there's a certain purpose for this, to avoid the office of the prosecutor basically firefighting every small case of
10,000,
exactly, a few thousands here, a few persons here, among others. I can understand that in practical terms, that appears to be the motive. But the wording of that provision is of such nature that I guarantee you, governments come, governments go. They may all exploit this to undermine the work of the office of the special prosecutor by pretty much keeping him in a very small, narrow area where the corruption involves huge sums. But let me just respectfully take the liberty to speak on something I think the former Attorney General, my good friend, just made a comment on in respect of going to courts. Since Kweku was speaking about disclosure of interests before I came, that the current EC boss, Dominic is my very good friend.
So you have disclosed,
which is interesting. I've been asked to disclose even more.
You were my junior in Chambers.
He was actually my senior, and since I won't disclose further. But yes, it's important to state this, that proceeding to court, if that should happen, will be extremely premature. And I think Dominic knows that very well. I know Dominic, and I know what he knows on this. He knows that very well. The principle of ripeness will not allow this. Not only the principle of ripeness, but the Supreme Court's own relationship with Parliament prohibits this. Yeah. In other words, where Parliament is considering things, the internal processes of Parliament, the Supreme Court is not interested.
Yeah. So it's a closed
they say
book.
the political, correct, closed book. It's a black box. The internal political processes are designed to take care of that. And Parliament has, through the speakership and other committees and other checks and balances within, is supposed to do that. Now, the only time the Supreme Court will intervene is where there's a clear breach of the lawmaking process. That one is within Parliament, but it is still outside Parliament. In other words, where Article 106, for example, is breached. So if the Speaker decides, for example, that there will be no committee, no consideration, the bill is passed. That one, someone can go to court, and the Supreme Court will intervene in that.
Or if you don't gazette and you come and lay.
So that's just the point I want to make. But in conclusion, I'm just going to say that the proposed law, short of one or two things I've seen inside which need to be rectified,
you can always
I think ought to be commended. I'm sorry?
I say you can always submit a memo to Parliament or the committee.
Yeah, when the invitation comes.
Yes. Yeah, so certainly in terms of answering your question as to whether this will rectify the current defect, the Attorney General suffers two things. I mentioned the first one, a proximity of interest and community with ministers, which makes the prosecution of ministers practically an uncomfortable business, and that's why we haven't seen it.
Right.
Because if it's me, I guarantee you I can't do it. It makes either I leave the cabinet and do it, or if I'm there, I can't do it.
They'll confess this to you privately, but they won't
exactly.
say it
in practice they say it, and I'm not kidding you. I've had private consultation with some of them. They'll tell you that you really expect me to prosecute this and still go and sit minute. But the other reason is that the Attorney General suffers from overload. The Attorney General is supposed to advise government on transactions, advise government on general issues of legal matters concerning Ghana, and is supposed to prosecute every criminal case in Ghana by the current arrangement or the interpretation of the current arrangement by some people. I think Dominic is one of those. That's the current, that the Attorney General is supposed to be in charge of general prosecutions. And therefore, even legally speaking, you may have a difficulty if you're carving out a law like this. That creates a separate creature. The reality is that the Attorney General suffers from overload. And in the absence of a structural realignment, as the bill seeks to do, I guarantee you, we'll continue to experience the same problem we've had for decades.
Yeah, but something, just to add something to what Dinabochi has said.
Yeah, in a minute.
Just in a minute. In other jurisdictions that I have, whose laws I've reviewed on special prosecutors' offices, what they have done to circumvent the situation where the sitting Attorney General cannot prosecute, fellow cabinet ministers, is to say that, look, where you have a conflict of interest, you appoint a special prosecutor, right? But guarantee the independence of that prosecutor in a way that will make it impossible for the Attorney General to then interfere with the prosecutorial, process, unless, of course, there's gross misconduct on the part of the prosecutor. And that is one of the things that I fear, because if you look at the Constitution and the fact that prosecutorial authority is vested in the Attorney General, is discretionary. So if, for instance, there is a misconduct on the part of the special prosecutor, can the Attorney General step in and say that you are abusing your prosecutorial authority and therefore you stop here?
No.
Or, for instance, something, who enters a nolle prosequi if there's the need for it to, for that to happen? Can the special prosecutor enter a nolle prosequi and abort a criminal trial? You know, there are a number of things that we need to...
The bill does not cater for that.
It does not cater for that.
There are supposed to be regulations to be made, right?
Yeah.
Yes, regulations to be made, but I don't know. In the section dealing with regulations, I didn't see anything about entry of nolle prosequi and the rest of them. But of course, as Honorable Obiamo has said, once it comes to consideration, we can take all these into account.
Okay, thank you very much. Let's hear Kweku on this.
The lawyers have spoken. I'm educated and better informed.
It's not left with the certified pocket lawyer.
Yes, you know, I'm excited about this particular concept of a special prosecutor. I've read the draft bill, what has been presented to Parliament, and what I like about it is the Attorney General Attorney General after his appointment can be he's hired and fired by the President at any time. Now I get a drift that this officer, special prosecutor, will have a certain security of tenure, even though it appears the President will appoint him.
Yes, as Chief Justice.
Yes, but it appears Parliament has been brought in.
No.
In
the appointment process?
Yes, read, unless I'm holding a fabricated version.
Okay.
There's
Yes,
a portion.
12 to subject to the approval of Parliament.
Yes.
By absolute majority.
That's right.
That's
it's in
my
there.
Bill, my bill is different.
12 to,
You know? So for me, that's the extension, that line, where this officer cannot, one, gets parliamentary approval, and two, cannot be fired, of course, just anyhow. There are removal procedures, just like we deal with the justices of the court. So for me, that's good.
Okay.
No, I think that can reinforce the point Mr. Abuji was making. You know, so to be honest with you, I'm hoping that Parliament, of course, we all would contribute our quota, but I believe in terms of the legislative engineering, this thing must come into fruition.
There are those who suggest that the appointment should commence with, an advertisement for interested parties to get in and for a process that will sieve.
Well, it still will not take away. It still will not take away the final authority who does the appointment. He may pick from the so-called thing. So I don't have a problem with any of those things. It may help in terms of transparency and accountability. But bottom line, it's still going to be the President who will do the final thing, and then Parliament is kicked in. The key point is that security of tenure that is given to this officer. It is 7 years. I think it's a brilliant idea. We need to deal with that thing. We need to allow it to come into being, and I'm hoping that there'll be bipartisanship in Parliament, and then of course some national consensus to go.
They also say this security of tenure thing in Ghana, if you look at it strictly in certain circles, it does not really prevent people from still playing to, the caprice and whims of a president or a party.
Well, then that's difficult. Being human, that human element is there, but the truth is that it helps to have it. Take a look at the judges. Okay, like we're saying, some come from different political divides, some have different philosophical outlooks, but once they are protected, they go by the law.
Yeah, but there's still
then what are we
the claims that there are some of them at the level of the High Court who are expecting to get promoted to Court of Appeal will still, even with the protection as a High Court judge, they are still trying to do something to, facilitate.
This was non-renewable tenure of 7 years.
Is that challenge an invitation? Is that challenge which is there? I agree, because it's a human element. Is it an invitation to proceed to heaven and bring somebody?
All right, I think that's a good note to take a break, and we will be right back. When we return, I'll share with you your messages on this and the first issue, because most of you are still sending on the first issue, and then we will deal with the president's encounter with the media. The issues that came up, we'll deal with some of the central ones. We'll be right back.